Good morning. I'm Tom Fair. I'm a partner in Thompson Hine's Business Litigation Group and also a member of our Office of General Counsel, where I do work on loss prevention and ethics. I'd like to welcome you to this year's Professional Conduct Hybrid Program. It's an in-person seminar and an online webinar called the Legal Ethics and the Future of Legal Services, the Evolution of Legal Practice in the 21st Century and Beyond. It's a very fancy sounding title. We're going to try and live up to it. Before we begin, a few housekeeping items. Today's program is being recorded. We will send a link to all attendees within 48 hours of today's presentation. The tape session will also be made available as a self-study CLA program. If you have any questions during the webinar, please wait until the end of each presentation to pose live questions. And if you're attending virtually, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We will answer as many of the questions as we can at the end of the webinar, or at least at the end of the sections. We will be offering CLE credit today for today's webinar. For in-person attendees, please fill out and turn in the evaluation form and sign in and out on the form at the registration desk. If attending virtually, please be sure to fill out and return the webinar affirmation and feedback forms that can be found in the handout section of the control panel located on the right-hand side of your screen. The documents provide instructions as to where to send the completed form. You will need to submit tracking codes, which will be announced at the end of each of the presentations. There will be 3 of them. We have received approval for CLE, professional conduct CLE in Ohio, New York, Iowa, Kentucky, and Nebraska. In the handout panel, you can also download a copy of the PowerPoint slides and bios of today's speakers, which I know you're going to want to put on your walls. Again, thank you for your interest, and if you have questions as we go along, please use the question box. So here is our schedule for the day, our agenda, and I would like to use this opportunity to introduce my fellow members of the Office of General Counsel who will be presenting today. I've already introduced myself. We also have with us Jen Roach, a partner in Antitrust, Competition, and Distribution section of our Business Litigation Group and a new member of the Office of General Counsel. Frank DeSantis, who's also a partner in the Business Litigation Group and chair of our Ethics Committee. J.A. Schneider from our Atlanta office will be speaking virtually. He's the vice chair of our Business Litigation practice in Atlanta and also a new member of the Office of General Counsel. And finally, the esteemed Karen Rubin, our counsel in the Office of General Counsel, who has primary responsibility for legal ethics, professional responsibility, and runs our very famous blog, The Law for Lawyers Today, a ABA winning blog worth subscribing to if you haven't yet. Okay, let me begin. Oh, I'm sorry, more housekeeping, we already did that. Okay, our first section today is the multi-jurisdictional practice of law and the risks it brings to the unlicensed or for the unlicensed practice of law. So let's start by defining our terms. And asking the question, are you going to violate the rules? What are these terms that we're talking about? Multi-jurisdictional practice of law is just what it sounds like. Practicing law in multiple jurisdictions, not just where your office is or where you're licensed. The unlicensed practice of law is just what it sounds like, practicing law in a jurisdiction where you have not been licensed to practice, which we can all agree is generally a legal no-no. Even before COVID, the expansion of remote work and people practicing where they weren't licensed was on the rise. But COVID shutdowns rapidly advanced that trend, prompting faster improvement in the technology used for remote practice and also forcing many lawyers formerly uncomfortable with or opposed to remote work to get comfortable with it. Remote work is just one reason why the multi-jurisdictional practice of law has expanded rapidly in the last decade. That and the increased national or global visibility of lawyers and clients has made it far more common for lawyers to be called on to negotiate, advise, litigate, or otherwise render legal services to clients in jurisdictions where they may not be admitted to practice. Occasionally, disciplinary authorities will bring charges against out-of-state lawyers for unlicensed practice, but this generally only happens if a lawyer is visibly and repeatedly providing legal services in a jurisdiction where they aren't admitted. But there's many other reasons why engaging in unauthorized practice is risky for you and your clients. Now, there are many situations where multi-jurisdictional practice occurs and raises the possibility of unauthorized practice. You can be appearing in a proceeding pending in another state, traveling to another state to meet a client or others, advising clients in another state about their goals, dealing with subject matter, whether law or property located in another state, or conducting negotiations with people that are in another state, or sometimes executing or filing legal documents in another state. In each of these situations, there's a possibility that someone will assert that you are engaged in the unauthorized practice of law, which can lead to many problems, including charges that you are violating the ethics rules. Sometimes those charges are generated by complaints from local lawyers or bar associations who don't like you coming in and poaching their work. But most often these charges arise when lawyers assert fee claims against a client located where the lawyer wasn't licensed to practice. This was first brought to our national attention in a case called Bierbauer out of California, which had to do with lawyers from New York who handled an arbitration in California and then got stiffed on their fees by the client. And when they sued the client in California to get their $1 million of fees, the court said, sorry, you weren't allowed to practice here, so you're not allowed to collect a fee for your practice. Now, that generated a reaction in the profession, particularly among transactional lawyers who are often practicing beyond state boundaries. And following Bierbauer, the American Bar Association adopted significant changes to several of the model rules relating to multi-jurisdictional practice, including Rule 5.5. And those changes are found in Ohio's current version of the rule, which is similar to that found in most of the states we're talking about today. So let's look at 5.5. 5.5 discusses a lawyer's practice in states where they aren't admitted. It addresses several issues, including what Ohio lawyers can do elsewhere and what non-Ohio lawyers can do here. And when I say Ohio, I mean fill in your state here. Rule 5.5A deals with Ohio local lawyers, and it says that it's a violation of our rules for an Ohio lawyer to practice in another jurisdiction in violation of that jurisdiction's rules. And we'll talk about that a little bit later, but notably, it's also a violation to assist another in violating the other state's rules. 5.5B specifically prohibits an unadmitted lawyer from establishing an office or other systematic and continuous presence in the state, or holding out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. Now, Rule 5.5C, however, expressly allows practicing lawyers who are in good standing in other states to practice here on a temporary basis if they meet one of these qualifications. One, if they are in association with an Ohio lawyer who's admitted in Ohio and who actively participates in the representation. Two, if they are admitted or authorized to appear, such as through a pro hoc or similar motion. Three, if they participate in an ADR proceeding related to the lawyer's work in the state where admitted, as long as that state doesn't require a pro hoc admission. Or four, if the work is reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted. Now, these exceptions all apply to temporary practice, but the rules don't define what temporary means. The comments to the ABA rule say that there is no test to determine if services are temporary, and that the label may apply even though the services are rendered on a recurring basis or an extended period of time. Each situation requires a separate analysis. And that's a point we're going to come back to often, which is you should not make any assumptions Whenever you're touching another state, it's worth looking at that issue, looking at the facts of your work, and making sure that you're okay there. But much of the time, out-of-state work is not temporary. Rule 5.5D addresses when systematic and continuous work by out-of-state lawyers may be permitted. 5.5D1 permits practice by unlicensed in-house lawyers working for their employers. Note that in-house lawyers must still register with the Supreme Court and still must seek pro hac admission if they want to participate in actual cases. Rule 5.5D2 allows out-of-state lawyers if the services offered are authorized by federal or other law. In some states, this exception also includes work arising under federal law, such as in patent or immigration work. But let's be clear, client matters arising under federal law still can involve related state law issues, so this is not an exception that will apply in many cases. Rule D4 permits practice where the lawyer is providing services authorized by his or her home state, but only as long as the lawyer does not solicit or accept clients in Ohio for representation before Ohio tribunals, hold herself out as an Ohio lawyer, or as being admitted to practice law in Ohio, or otherwise violates rules 5.4, 7.1, or 7.5. Now, Rule 5.5 has been adopted in most states, and I will emphasize here that Ohio lawyers cannot simply rely on what the Ohio version of Rule 5.5 says. It's important to pay close attention to the specific facts of each state's version of Rule 5.5, and as many of them will vary, and the interpretations applied by the local authorities may well vary as well. Remember that you're subject to the disciplinary authority of your home jurisdiction, Ohio for most of us, regardless of where your conduct occurs. And you're also subject to the disciplinary authority of the jurisdiction where you might be found to be practicing. So Rule 5.5 is adopted by various states and allows lawyers from outside that jurisdiction to practice in that state, but you have to look at that state's version of 5.5 to make sure that you're okay and that you don't fit the definition of unauthorized practice in that state. What is or isn't proper usually requires analysis of both states' rules because they can have varied definition of what counts as the practice of law and what kind of practice by out-of-state lawyers is permitted. For example, Arizona and Minnesota, New Hampshire, and North Carolina allow out-of-state lawyers to maintain more than a temporary presence there when their practice relates solely to other law, like federal law, or the law of another state, or tribal law, while other states, like Ohio, do not have that exception. So what are the things that you can do that can lead to engaging in the unauthorized practice? It can happen a lot of ways that you don't anticipate. Some ways are obvious, like filing things in court, participating in ADR or administrative proceedings. We all know that representing clients in out-of-state court proceedings almost always requires a pro hac vice admission, and the rules and procedures for that admission will vary from state to state and even court to court, so they must always be checked. But you can also be deemed to be improperly practicing and participating in those proceedings by doing other things, like preparing witnesses or responding to document requests. So it's important whenever you're involved in one of these out-of-state matters to look and see whether you are required by that state to do more than just sit in your state and actively participate. Now, as we discussed, the requirements can also be applied to other less formal proceedings like workers' compensation matters, tax matters, licensure, and other administrative proceedings. Sometimes even just filing reports with the state agency on behalf of a client can be deemed practicing law and raise the possibility of a charge of unauthorized practice. Many state administrative agencies have specific rules on who can and can't practice there. So when in doubt, you should always check with that agency and the local version of Rule 5.5. Also be aware that many states limit how often lawyers can appear pro hac vice in that state or create other obstacles to the admission of out-of-state lawyers. Some states will only allow you to appear in 3 cases in a year, which can be problematic depending on who your client is and who you're working for. So you have to always check the local rules, and generally in those situations have a local counsel. Oh, sorry. Transactional representations also have lots of opportunities for engaging in unauthorized practice. In transactional work, there are many factors about what you do or might not do that will touch another state where you aren't licensed. For example, you may visit an out-of-state client, go to their locations around the country in states where you aren't licensed, talk to people and give advice. Then you're in the realm of practicing law, and you have to figure out whether you fit within one of the exceptions. You may be dealing with out-of-state parties, and there may be property in those states. If the other parties to the transaction are located in another jurisdiction, the transaction begins to look more like an out-of-state transaction, especially because some or all of the subject matter, like the real estate, the inventory, might be located there. And at different points, you're going to be touching different aspects of that state's law. In those situations, you need to consider immediately whether you need local counsel. You may be getting into the area of not just an ethical violation, but because of local rules that may affect the ability of your client or the rights of your client, you might be talking about potential malpractice liability if you haven't consulted with and engaged local counsel. You have to understand also that the rules and the application of the rules vary greatly from state to state, and they arise in both litigation and non-litigation work. So for example, Pennsylvania found unauthorized practice when a lawyer represented his wife and stepson in a high school expulsion. Colorado found it when an unlicensed lawyer sent a letter to opposing counsel to initiate settlement discussions. Connecticut found UPL when a Florida lawyer represented a Connecticut resident in a loan modification. The lawyer was reprimanded and also disbarred in Florida as well. The Florida Supreme Court found that a DC lawyer was guilty of unauthorized practice for representing parties in security arbitrations in Florida. Illinois found it when an unlicensed lawyer represented clients before the Illinois Racing Board, which I assume is horses, but who knows. Illinois also found that an out-of-state lawyer could conduct a federal immigration practice in Illinois. So sometimes these rules, the states will be inconsistent even with themselves. Kentucky found unauthorized practice for handling a workers' compensation matter. Minnesota found that when a Colorado lawyer sent emails to a local lawyer on behalf of his in-laws in a dispute over a collection matter. New Jersey found it when an out-of-state lawyer represented New Jersey residents in a real estate purchase. The Ohio Supreme Court has concluded that there is no doubt that an individual who is not licensed to practice law in Ohio, who negotiates legal claims on behalf of Ohio residents or advises Ohio residents as to their legal rights or the terms and conditions of a settlement, is engaged in the unauthorized practice of law. Ohio also found unauthorized practice for soliciting Ohio residents to file tax assessment complaints and appeals to the Ohio Board of Tax Appeals. South Carolina found that a California admitted lawyer engaged in unauthorized practice for representing South Carolina residents in negotiating a modification of the loan on their South Carolina residents. Wisconsin found that a New Jersey lawyer can't represent clients in a medical peer review proceeding because the lawyer was not admitted to practice in Wisconsin, and then also found that he could not appear pro hac vice because the Wisconsin rule authorizing pro hac admissions didn't apply to anything other than court proceedings. So again, the rules will vary greatly, and every time you're going to another state to do something, it's worth looking at it, figuring out whether what you're proposing to do will be considered the practice of law and whether you fit within one of the exceptions for a temporary practice or whether you need to engage local counsel. So what are the risks of unauthorized practice? Some are obvious. You can have ethical sanctions in multiple jurisdictions. Most states assert disciplinary jurisdiction over out-of-state lawyers who are admitted pro hac or who otherwise practice in the state, and violations found in that state will usually be the subject of reciprocal discipline here in Ohio. In several of the cases that we've seen, people who are sanctioned out of state for improper conduct will also lose their license here or at least be reprimanded here. Now, as I said earlier, the ethical charges are relatively infrequent, but the real risks are in the practical aspect of your practice. So you can have fee collection problems. Just like the Bierbauer case that we discussed earlier, many cases around the country have found that a lawyer who is trying to collect a fee for work that can be characterized as unauthorized practice lacks standing to collect that fee. Other courts in other states have been more forgiving of that, but anytime that you're into that kind of dispute, you're already losing. So you want to be careful, you want to address it upfront if possible and avoid the dispute later. One of the less understood aspects or problems associated with unauthorized practice is the fact that what you do on behalf of the client might be considered a nullity. It might be stricken. So there's examples all over the country where filings made by unlicensed lawyers are stricken or deemed a nullity. North Dakota found that out-of-state lawyers who successfully persuaded a state agency to reverse a workers' compensation award were engaged in unauthorized practice and voided the agency's decision. Also, out-of-state lawyers engaged in UPL by filing administrative appeals in many jurisdictions, and the appeal itself will be found to be a nullity. In other cases, complaints, answers, tax filings, and other papers have been stricken. And in at least one case, a client's case was lost because the statute of limitations had run by the time it was discovered that the complaint was filed by an unauthorized or unlicensed lawyer. So that lawyer faced not only an ethical problem, but a malpractice claim because they had blown the statute of limitations. There's many other kinds of filings that one can imagine might be stricken or deemed null, and it's easy to see how these could lead to both ethical charges and malpractice suits. So it's always better to address the questions early before it's too late to figure out that you need local counsel. And then there was COVID. As we talked about earlier, as the pandemic spread in 2020, many law firms closed their offices and switched to working remotely, and many lawyers began working from states where they were not licensed. Some had always lived in one state and worked in another, a situation common to lawyers who practice in New York and live in New Jersey or Connecticut. Others moved to be near family members who could provide childcare or needed elder care, and still others just moved to a location with better weather or a lower cost of living. So is this a problem? In general, no, but only as long as the lawyer doesn't advertise in the other state, hold themselves out as available to practice there, or provide legal services to local residents for matters related to that state's jurisdiction. So if you're hanging out in your house in Florida and you start advising your neighbor about what he ought to do about his real estate problem, you've got a problem. But if you just sit there like Frank and type away on your computer and answer questions for your Ohio clients, then you should not have a problem. Several states' ethics opinions have already addressed these issues, including Florida, where the unauthorized practice of law is still a felony. So that was a big relief to many people who live, whose houses are there. But other opinions have come out in the District of Columbia, in New Jersey, New York, Pennsylvania, and Utah. And these opinions are coming out frequently all over the country now. And the touchstone of all of them seems to be one issue, which is, are you conducting your practice in another state sitting in your bedroom, or are you conducting a practice that touches that state? Are you serving or attempting to serve clients in a state where you aren't licensed? In general, the opinions have been very solid to say that you can sit wherever you want and conduct your practice, as long as most of what you're doing is on your computer. If you're starting to talk to people or reach out to people in that state, you're going to be in danger of unauthorized practice. Again, I'll emphasize every situation is different. Every time you are thinking about doing work in another state, it's worth taking the time to think about what you're going to do, how does it touch the state, and looking at that state's rules to understand whether you might be in violation of them. As always, whenever you have a question, the most important thing to do is call your ethics gurus. We are always available to do that. There's nothing more than we like than talking to people about fun ethics problems. So unless there's any questions, I am now going to turn the podium over to Jen Roach, who's going to talk to you about the duties of in-house counsel.
Thanks, Tom, and good morning, everyone. There we go. Okay, I've been doing a lot of learning as a recent member of the Office of General Counsel, so I picked 3 things this morning that I thought might be interesting to folks that are in-house counsel and work in law firms as well. So, and they should apply all whether you're licensed in Ohio or in another state as well. Everyone here is either a supervisor or supervised in some capacity. So we'll talk a little bit today about the duties inherent in each of those roles, as well as the duties that you have regarding supervision of non-lawyers. Next, we'll talk about when there is a dispute involving your client, what are the rules involving when you can communicate with an adversary's current or former employees. And last, we'll talk about some of the restrictions that can be put on opposing counsel as part of a settlement agreement, and a preview as there really aren't too many with respect to their ability to practice in the future. So whether supervised or supervisor, every lawyer who is authorized to practice is bound by the rules of professional conduct and needs to be, is accountable to adhere to those rules in their individual capacity. All lawyers are responsible for their own conduct, no matter how long they're practicing or where they're practicing, if it's with the government, an in-house position, or in a law firm. And the same set of standards for professional discipline applies regardless of what organization you're associated with. And although you're responsible for your own conduct, Rule 5.1c also includes a general principle of responsibility for the acts of another. 5.1c says that a lawyer who is a direct supervisor or manager shall be responsible for another lawyer's violation of the rules of professional conduct when the supervising or managing lawyer has knowledge of the misconduct and ratifies it, including when that lawyer directs the conduct to take place, or knows of the misconduct at a time when the consequences can be avoided or mitigated, but fails to take reasonable remedial action. And the comments provide an example of this. If a supervisor knows that a subordinate misrepresented a matter in a negotiation with an opposing party, the supervisor, as well as the subordinate, has an ethical duty to correct the resulting misapprehension. And the duties that are imposed here by 5.1c do not alter the duty that the supervised lawyer has on their own with complying with the rules of professional conduct. So what are the responsibilities of a supervised lawyer? Is it sufficient for the supervised lawyer to say, the partner told me to do this, my boss told me to do this, my manager in the legal department told me to do this? No, it's not. That's definitely not a free pass under the rules. And acting at a supervisor's direction is not going to be an excuse for any professional discipline or try to avoid any discipline for misconduct. Rule 5.2 covers this situation and says that a lawyer is bound by the rules, notwithstanding that they are acting at the direction of a supervisor, with one exception. If the ethics question is unclear, the resolution of the question is unclear, then the supervised lawyer can rely on their supervisor's reasonable decision about how to proceed. A good example of this would be when 2 clients may have a conflict of interest. It's a complicated analysis under Rule 1.7. There's no clear answer. If the supervisor makes the decision that there's no conflict, the supervised lawyer can rely on that and won't be held to have violated the rules. Now, all lawyers interacting with non-lawyer assistants also have responsibilities under Rule 5.3, and this applies whether the non-lawyer assistants are inside the law firm or outside. If you're using vendors, for example, third-party vendors. The rule provides that the lawyer must take reasonable steps to ensure the firm has measures in effect that the non-lawyer will act in a way compatible with the professional obligations of the lawyer. The comment to Rule 5.3 indicates that for the lawyer, an appropriate instruction and supervision to the non-lawyer assistant about the ethical aspects of employment, particularly concerning the maintenance of confidentiality and to not disclose information relating to client representations, is something that's important and key here. An ABA opinion from 2008 referencing non-lawyers who are outside of a law firm or legal department that are assisting on matters notes that things like reference checks, background checks, and resume reviews would satisfy this obligation under 5.3. A lawyer can be responsible for non-lawyer conduct if that conduct would violate the rules of professional conduct in two circumstances. The lawyer orders or with knowledge of the misconduct ratifies the misconduct, or like we just talked about with respect to a supervised lawyer, knows of the misconduct and when they could have remedied it to avoid the consequences, fails to take reasonable action to do so. Next, we'll talk about the no contact rule under 4.2 and whether you can contact adverse current and former employees. A key issue in litigation sometimes is whether you can have this kind of contact, because you certainly can uncover a treasure trove of information in this type of informal discovery, particularly if you're in contact with disgruntled employees and can review them and interview them and find out facts about your matter in advance of conducting formal discovery. And whether you can communicate with these current or former employees depends on the circumstances and what jurisdiction you're in. The basic rule is that a lawyer shall not communicate about the subject of a representation with a person the lawyer knows to be represented without the consent of the other lawyer, or unless the lawyer is authorized to do so by law or a court order. The rationale behind this rule is pretty easy to figure out. You want to protect the represented person against possible overreaching by adverse counsel. It safeguards the protection of the attorney-client privilege and prevents it from there being an uncounseled or inadvertent waiver, and prevents interference with the lawyer-client relationship. Now, an adverse corporation can't say that all of its current and former employees are represented by the general counsel and make them off limits and unable to be contacted by opposing counsel. Something like this is not supported by the rules of professional conduct, and such a declaration does not establish a legal representation of all employees, and it certainly could create conflicts of interest for that corporation. So even if a corporation's lawyer says, we represent all current and former employees, you can still undertake the analysis about whether you can communicate with certain employees. The ability to contact current employees is certainly more limited than it is former employees, given the rationale behind the no contact rule, but there is a balance to be struck between a blanket representation of all current and former employees and communication with current employees. So different jurisdictions have different tests, and as Tom mentioned before, you need to check where you are practicing as well as a jurisdiction where the employee might be located, whether current or former, that you want to be contacting. In most jurisdictions, one of the key factors in their test is going to be how much authority or involvement did the employee have related to the issue that's causing the adversity. And this test really applies to the current employees. So in general, although you need to look at the specific jurisdictions to confirm all the factors that you need to evaluate in making this assessment as to whether you can contact a certain current employer, there are going to be categories of employees of a corporation who are considered represented by the corporation's lawyer and that are shielded from contact by adverse counsel. So you should not be contacting employees without permission of opposing or corporate counsel, where employees have managerial responsibilities. They regularly consult with the general counsel concerning the issue at hand or the matter that's in dispute. If they have authority to obligate the company with respect to the matter, or where the employee statements, acts, or omissions may be imputed to the company or constitute admissions by the company. So those are the general categories of employees, current employees that you should not be contacting. Caution should definitely be used when communicating with current employees who don't fall into these categories in any event. If there's a close case, it's better to seek sometimes counsel or consent from the corporation's lawyer. And if that's denied, then you certainly can undertake some informal discovery or even limited formal discovery to determine what that current employee's role is with the company, and if it is someone that you can contact or if they're legitimately off limits. Again, there are many variations by state, so check the case law and ethics opinions in the state where you're located and the state where the employee is located to determine whether you can have that ex parte communication with a current employee. Now, former employees are in a different category because they have no managerial authority, they can't act on behalf of the company, they're not binding the corporation, and their statements can't be introduced as admissions. So they're generally fair game and outside the scope of the no contact rule. So if the former employee is unrepresented, you can contact them without notification or consent of the corporate lawyer in general. The Ohio Board of Professional Conduct issued an opinion in 2016 that said that the lawyer's communication with an unrepresented former employee does not violate Rule 4.2, even if the prior acts of that employee could be imputed to the corporation. And that followed a similar 1995 ABA opinion, which said that the no contact rule does not prohibit contact with former employees of a corporation, even if the former employee had been in a category where the communication was prohibited when employed. So before interviewing a former employee, you should disclose your identity and fully explain that you represent a client adverse to a former employer, and inform the former employee not to divulge any privileged communications in your interviews or in your conversations that the former employee may have had with corporate counsel or outside counsel while they were employed. And finally, try to take care not to solicit information that you know or reasonably know to be protected by the attorney-client privilege. Now, some jurisdictions may consider whether a former employee was extensively exposed to privileged information during the course of their employment. So again, this is why it's important to look at the jurisdictions that are relevant to see if that's a factor that you should consider before contacting a former employee. Now, obviously, if the former employee is represented by independent counsel, or if the corporation's lawyer has agreed to represent that former employee in the matter, then you can't contact them without consent. And one other thing to note is that Rule 4.3 requires a lawyer not to advise an unrepresented former employee other than to tell them to seek the advice of counsel in the matter. So that's another thing to be aware of when you're having those communications with the former employee. This is sort of a kitchen sink of issues that come up under the no contact rule. In-house counsel may be contacted ex parte by opposing counsel. The in-house lawyer is the lawyer for the corporation and as such is not treated as a client. So the prohibition on communication with an ex parte with an adverse employee would not serve the purpose of the rule to prevent the lawyer from taking advantage of a non-lawyer. So in this instance, the opposing counsel can contact the in-house corporate counsel. Obviously, your clients can talk directly to each other If the business folks want to make offers of settlement or other communications with the adverse party, that's perfectly fine. But lawyers need to make sure that they steer clear and avoid any intrusion in that client-to-client contact. In class actions, defense counsel can contact members of the class before certification. I should say the members who are not named plaintiffs without violating the no contact rule. And two things that are not relevant, the sophistication or the experience of the current or former employee that you want to contact, it doesn't enter into any of the analysis. And you can't direct a non-lawyer to make contact and do what you ethically could not do with a current employee without consent, because professional misconduct that violates a rule of professional conduct, if you did it, would come right back at you if you instructed someone to do it on your behalf. So last topic, we'll talk about the ethical limitations in settlement agreements. Can you limit a lawyer's future practice or claims that the lawyer can bring in a settlement agreement? The short answer is no. Rule 5.6b provides that a lawyer shall not participate in offering or making an agreement in which a restriction on the lawyer's right to practice is part of the settlement of a claim or controversy. And this prohibition is intended to limit both sides of the dispute. It applies not only in the litigation context, but also ADR and administrative proceedings. There's a pretty extensive Ohio Board of Professional Conduct advisory opinion from 2019 that discusses the various types of provisions that may be included in a settlement agreement and used as a direct or indirect restriction on the lawyer's right to practice in the future. And not all of them are obvious on their face that they would actually be such a restriction. So it explains in quite detail how you focus the analysis on what the impact is on the lawyer's right to practice in the future. A requirement in a settlement agreement that a lawyer affirm that she does not represent any other person contemplating filing the same or similar claims. This opinion concludes that violates Rule 5.6b because although it's not a direct prohibition on its face, the lawyer may not be able to make that affirmation where the lawyer has undisclosed clients with similar claims without violating or breaching the duty of confidentiality or creating a material limitation conflict for that undisclosed client, even if the client would consent to disclosure of their identity. So the opinion found that this was an indirect restriction and prohibited restriction on the practice of the lawyer and therefore violated Rule 5.6b. Similarly, including an agreement not to solicit new clients with similar claims in a settlement agreement is an impermissible restriction under 5.6b. The advisory opinion says that this prohibition has a practical effect of substantially and impermissibly restricting a lawyer's ability to practice law and certainly to solicit future clients. Non-disparagement clauses could violate Rule 5.6b, but it depends on how broadly they're worded. If the prohibition is just prohibiting the lawyer from making any malicious or defamatory statements post-settlement, there probably is not going to be an issue with a provision like that. But if the non-disparagement provision prohibits a lawyer from filing a new action against the defendant or advertising the lawyer's previous experience related to that defendant, the advisory opinion says that this is an indirect restriction on the practice and also would be prohibited. And with respect to the mass tort and class action context, although there are no Ohio opinions, an ABA opinion basically applies the same analysis to class action settlements and concludes that a lawyer cannot ethically agree as a condition of settlement to refrain from representing future claimants. Can you prohibit the opposing lawyer from using information gained during the litigation in future litigation? The 2019 Ohio opinion addressed the impact of confidentiality provisions on the lawyer's ability to practice in the future. and said that a broad requirement that the lawyer keep all the information learned in the lawsuit confidential may limit the effective representation of future clients against the same defendants, so such a restriction would be prohibited. Now, if the restriction on the use of confidential information applies to the terms of the settlement agreement or sealed information in the lawsuit, the Ohio opinion said that a provision like that would not violate 5.6b. A similar ABA opinion permits an agreement to maintain non-public information about the case as confidential, but would find a violation of 5.6 if there was an agreement to prevent the lawyer from using all information obtained during the lawsuit. A few jurisdictions have found that overbroad provisions restricting future practice do not void a settlement agreement, but that doesn't mean that the lawyers participating in that agreement would escape professional discipline. Tom promised he has an example of the no contact rule that he would like to share with everyone. So he'll be back up here to provide you with your tracking code information and give you a real life example.
So the real life example comes out of a case that we handled out of our Cincinnati office last year. And it had to do with a large corporate entity that was in a dispute with one of its former employees. And it was essentially a non-compete issue. And the CEO of that entity, as was revealed in emails that we got later in the case, called his general counsel and said, I know this guy is violating the non-compete. I want you to have one of our paralegals call up his office and pretend and see what kind of an appointment they can get that would be evidence that he's violating the non-compete. They had a very savvy paralegal who the general counsel employed to do just what the CEO had asked. She not only made the call, but before she did so, she decided to set up something I didn't know you could do, but some kind of block on her phone that would show a different area code that she was dialing from than what she was really dialing from, so that they couldn't figure out that the call was coming from headquarters. And then she called up, used a fake name, said, I'd like to set up this kind of appointment, inquired as to various aspects of what kind of treatment she could get, and gave a fake Gmail account. It was a real Gmail account, but one that she created for this under the fictitious name to get information about the appointment. She reported back to the general counsel the very successful results of her call, and then the general counsel promptly took that information and forwarded it to their litigation counsel. The litigation counsel promptly filed a lawsuit alleging a breach of the non-compete agreement, and that case was eventually settled without much discovery. Then later on, they suspected that he was violating the agreement again and did the same exact thing. Now, in the first suit, when the email went to the counsel, the outside counsel, the main partner then circulated it to the whole team and said, look what we got, you're gonna have so much fun with this guy's deposition. When the company eventually filed a motion for sanctions for violating the settlement in the first case, and discoveries started occurring, they found these emails that were shared among everybody, including evidence that the paralegal had made 2 more calls after the fact in order to ascertain a subsequent breach of the settlement agreement. When we got those emails, we went directly to the court and said, you've got a violation of the rules here. You had contact with a represented party made by a lawyer because it was the in-house counsel, the general counsel, was in fact a lawyer, licensed in Ohio. He was subject to the rules prohibiting contact with represented parties. And he was also subject to the rules that said you can't have somebody else do what you're not allowed to do. The court immediately said that we could have all of the, after an in-camera review, that we could have all the emails, and then effectively granted a motion for sanctions for the conduct, dismissed the case, awarded a substantial amount of fees to our client for all the time that he had spent fighting these lawsuits. And then the client reached out to the Ohio Supreme Court and filed grievances against the general counsel and all the lawyers at the firm. And the essence of those charges, which are still pending, is that the general counsel breached the no contact rule, and then his other counsel, also Ohio licensed lawyers, were made aware of his misconduct, failed to report it, and worse than that, actually utilized it in court in furtherance of a claim. So they all had grievances. They're all looking down the barrel of it. The law firm no longer has that client as far as we can tell, and the matter will go on for a long time. So the moral of the story is it's a very significant rule. There are a number of cases around the country and several in Ohio that make it very clear that people who do this are in trouble and will be held to account, and it will have a significant negative effect on the company that you work for if you do it even as an in-house counsel. So that's my story. It was one of the more fun cases of 2019. All right, so I think we are coming up on our break. If there are no questions anywhere, Alice is not here, but my understanding is we have a 10 o'clock break, that we are back at 10:15. So there are refreshments, bagels and other things in the other room for anybody who wants them. If you're online, have your own snacks and enjoy them. We'll see you at 10:15.
Okay, we're going to get started again. Thank you. First, one housekeeping detail. The tracking code is on the screen, TH1208L, whatever that means. All right, so I am Frank DeSantis, and my session is Artificial Intelligence and Legal Ethics. So what are we going to cover? First, we're going to talk about what is AI, how is artificial intelligence used in the law practice? How will AI affect the legal profession's economic structure? What are the legal, ethical, and risk management issues associated with artificial intelligence? And who will provide artificial intelligence-based legal services in the future? So what is AI? My wife uses that term to describe what she claims is my propensity to pontificate on subjects I know nothing about. So what is artificial intelligence really? To prove my wife's point, let me give you this definition. AI is the statistical, inference based on very high level math, automatically computing and adjusting the step size for gradient-based neural net training algorithms by estimating and tracking the largest unit value of the Hessian matrix of a neural net's aerial surface. I like this definition a little better. AI means teaching a machine to do a task thought to be human, generally much faster and usually more accurate than humans can do. So how is artificial intelligence used in the legal profession? Most of you are, and probably all of you are familiar with these concepts. E-discovery, probably the first and most commonly used artificial intelligence by lawyers, the software that enables a vast number of documents to be surveyed, pertinent and important documents to be selected in a fraction of the time it would take a lawyer. Expertise automation, commoditizing legal knowledge that enables clients to find answers that otherwise would require a lawyer. For example, how to draft a will. Legal research, LexisNexis, Westlaw, among others. Contract and litigation document analysis and generation. AI providing assistance in drafting briefs and contracts using a huge database of precedent. Predictive analytics, AI using data to assist in analyzing what might happen in the future. What has this judge done in the past on this legal question on these facts? So how does Thompson Hine use AI? Well, we use licensed software for e-discovery, like most law firms. In fact, I think it's safe to say that using artificial intelligence in e-discovery is now the standard of care for lawyers. Kyra Systems, our firm engaged in a multi-year, multi-product search to identify an analytic software that we wanted to integrate into our legal services. Kyra combines rule-based systems, essentially keyword searches, with machine learning artificial intelligence, essentially learning based on a series of examples, which creates a probability analysis for new examples. We use Kyra now in M&A due diligence, contract management, and real estate abstracts, and are looking into other applications. Along with licensed products, Thompson Hine has developed other artificial intelligence products using experience and data harvested internally. Budget and work planning tool. It's a user-driven enhancement to our proprietary budget and work planning tool that lets budget creators specify a precedent engagement and upload matter actuals to a budget draft, pre-populating time capers, staffing levels and hours. And we budget by actuals, and it can be used for any type of matter. Litigation fee predictor is a artificial intelligence tool to assist budget creators with drafting based on prior specific experience. An M&A deal, essentially all of these tools are used by Thompson Hine to assist the firm, among other things, to provide clients with predictability and transparency with respect to our legal fees. So how will artificial intelligence affect the legal profession's economics and structure? What will be the role of lawyers in the future, and how might this change law firm structure? As AI continues to develop, lawyers of the future will provide those human functions that AI cannot now and likely never will be able to provide: judgment, empathy, creativity, adaptability. Judgment, for example. Let's say a predictive analytical tool tells you that a particular judge has ruled several times on an issue that is going to be adverse to your client's position. Do you just accept that, or do you evaluate whether there are other factors to consider? You know the judge. You know that she is very hard on parties who have provided false testimony. Opposing party was caught in a lie in a deposition. You use your judgment to evaluate how that could affect the outcome and temper the results of the analysis created by AI. Litigation skills. You're examining opposing party in a deposition. Because of a twitch or because he looks away when you ask a question, you know inherently that's an area you have to go after that witness aggressively on cross-examination. No machine will ever be able to do that unless Isaac Asimov is a prophet. So what's the impact of what's the possible impact of artificial intelligence on the structure of the law firms? Some commentators suggest that the continued development and use of AI will make the pyramid structure of most law firms obsolete. Artificial intelligence will replace the large number of associates hired to work through mundane chores in order to learn the practice. AI will accomplish the more routine and tedious aspects of practice, leaving lawyers to do the more skillful and professional parts of the law. Thus, hiring and training will have to evolve along with artificial intelligence. There'll be more particular and experiential-based training, including the use of and analysis of artificial intelligence. So what are the legal, ethics, risk management issues in providing legal services using AI? The duty of competence. The principal ethical obligation of lawyers where they are developing or assisting clients in identifying and using AI solutions is the duty of competence. Most states have adopted the ABA portion of Rule 1.1, which provides that technological competence falls within the lawyer's general duty of competence. Does that mean that all lawyers are going to have to be able to write source code? Hardly. Most of us are not computer scientists. But at a minimum, lawyers will need to be able to identify and access the expertise to assist them in making judgments on which of several products or services of artificial intelligence actually achieve the results they promise, and which is preferable for a given set of problems. One commentator put it this way: in practice, lawyers need to find trusted providers of AI-based solutions, and they need to ask smart questions to providers whose AI tools they are considering. Lawyers need to understand at a basic level how the solutions work and how the solutions were developed. What is the risk of lawyer liability if an AI solution fails? This is a complicated area right now, and one for which there is very little precedence. Generally, the law follows society by 10 or 20 years, so we're still kind of figuring out what's going to happen when an AI solution fails. My view is if a lawyer satisfies her duty of competence, as previously discussed, that will go a long way in insulating her against potential liability for AI solution related problems. Clearly, there are other things that should be done. Due diligence with the providers, allocation of risk with AI providers, but basically satisfying the competence requirement is a threshold. Duty to supervise. As Jen described, Model and Ohio Rules 5.1, 5.2, and 5.3 place an express duty on lawyers to supervise subordinates, including third-party providers, in the provision of legal services. In the AI context, once again, to satisfy this requirement, lawyers will need to satisfy their duty of competence. Is the selection of the AI provider appropriate? Is the AI solution to be used the right product? We may not understand how the AI product functions mechanically, but we can ask questions that could surface issues associated with its use. Bias, for example. What data was used? In what other situations was this product used? Did it ever fail? If it did fail, what were the reasons? Those are the kinds of questions that we'll need as lawyers to satisfy in order to satisfy our duty of competence, in order to satisfy our duty of supervision. Confidentiality issues. Rule 1.6 provides a very broad and significant duty on lawyers to preserve confidentiality of their clients' information. Obviously, agreements with third parties providing AI products and solutions must include provisions that protect the client's information. How is it stored? Who will have access? Interesting questions will arise and are arising in the context of artificial intelligence ethical obligations with respect to confidentiality. After a case that utilizes artificial intelligence system trained on a client's data ends, can the lawyer use the AI system trained on the first client's data with a second client? Can the client use the trained AI system in a subsequent matter when represented by a different law firm? Who owns the tool? Is it the client or is it the lawyer? When the tool is based on the client's information but is not expressed visually. I mean, you're storing the information in the system, so nobody will be able to recognize the information you're using. So can a lawyer use that information to develop a tool and then utilize it with other clients? Are you really utilizing client information? Do you need client permission to do that? These are questions that we haven't caught up to yet. So who will be the future providers of AI-based legal services? There's a developing significant competition with lawyers in the providing of legal services generally, and JA is going to talk about that. With respect to providing AI legal-based solutions, at least one commentator has suggested that cost pressures will cause clients to increasingly seek to avoid as much as possible the involvement of the irrelevant middleman, the law firm. This may be true of law firms who merely serve as seeker or conduit of AI-based products, but for visionary and innovative law firms that are developing proprietary artificial intellectual solutions on the cutting edge, say firms like Thompson Hine, to quote Mr. Huxley, this is a brave new world. So that wraps up. Are there any questions on artificial intelligence? Okay, Jay, taking over.
Okay, thank you, Frank. Good morning, everyone. J.A. Schneider, partner here in the Business Litigation Group of Thompson Hine here in Atlanta, Georgia. And today I'm going to be talking about alternative business structures for law firms. Eric? Yep, okay. Sorry about that. Okay, so what is an alternative business structure, and what is it not? According to the Arizona Supreme Court, an ABS is an entity that provides legal services and has non-lawyer ownership, managers, or decision makers in the business. I think more specifically and maybe more simply, it's really just a law firm which can have non-lawyer owners and generally provide services beyond legal advice. I want to distinguish this term from another term or concept that you see a lot in the literature, in the legal news, alternative legal service providers. Sometimes you see these terms used interchangeably, but generally an alternative legal service provider, or an ALSP, generally refers to law firm-owned services, service providers of ancillary legal services, things like document review, e-discovery, M&A due diligence, maybe even title insurance, things like that. Alternative legal service providers are generally permitted in the United States and are therefore pretty commonplace by now. Approximately a third of AmLaw 100 law firms have some sort of in-house separate legal entity that provides ancillary services as a separate business. Also, alternative legal service providers are governed by Model Rule ABA Model Rule 5.7, as opposed to Rule 5.4, which governs alternative business structures. As we're about to see, govern, maybe a little bit of a misleading term. But back to the topic at hand, alternative business structures or non-lawyer owned law firms. So what's so special about a non-lawyer owned law firm? Well, you can't do it. So let's take a look at ABA Model Rule 5.4, which was adopted in 1983. 5.4b says a lawyer shall not form a partnership with a non-lawyer if any of the activities of the partnership consist of the practice of law. 5.4d says a lawyer shall not practice with or in the form of a professional corporation or association practice law for a profit if a non-lawyer owns any interest therein. Not going to read through all of it, but the rule's clear enough. 5.4b says you can't make a non-lawyer your partner. 5.4d captures the literalists for folks who might try to get around that rule with a different form of business entity. 5.4a and c deal more with fee sharing and management. B and D really cover the rule about non-lawyer ownership or investment in those firms. Historically, the only exception to this edict has been for, and this is in 5.41, a fiduciary representative of the estate of a lawyer may hold stock or interest of the lawyer for a reasonable time during administration. So if you die, you can do it, or at least your surviving husband and wife can do it on your behalf, but only for a reasonable time while they're trying to administer your estate. Until very recently, all states have followed this rule and had followed this rule and adopted it either verbatim or close enough. So this is the rule that governs in Ohio, governs in Illinois, governs in New York, governs in Georgia. Each of those states' respective rules, 5.4 B and D, cover this, and similarly prohibit non-lawyer ownership of law firms. Now, I didn't pick these names out of a hat, and as you might imagine, if you look at my signature block, these are the states where Thompson Hine has offices, and you'll notice I said states. So these states aren't particularly special, and until very recently, no state had provided any meaningful exception, although many have looked at doing so, and we'll talk about that in a little bit. This has been the rule going back more than 100 years. It was codified in the 1928 ABA Canons of Ethics. It continued on in the 1969 Model Code of Professional Responsibility, and then eventually adopted in the Model Rules in 1983. Although certainly by 1983, at the least, people were seriously starting to question the basis of the rule. It did make it through and remains the rule today in almost every U.S. jurisdiction. You've seen these have now been allowed in at least Australia and the United Kingdom for a little while, but at least in North America, they are definitely in the minority. We were talking about, I've been referring to states. In 1991, the District of Columbia becomes the first U.S. jurisdiction to stray in any significant sense from Model Rule 5.4. This is always one of my favorite quotes, and I threw it in there. Washington leads the way again here. It still amazes me that people were making fun of their sports teams in 1904. It seems like they had bigger problems to deal with back then, but apparently not. I'm glad they were enjoying themselves. But in any event, District of Columbia 1991 strays from Model Rule 5.4 B. So they didn't completely abolish 5.4, but they softened the rule some to say a lawyer may practice law in a partnership or other form of organization in which a financial interest is held or managerial authority is exercised by an individual non-lawyer. There's 4 conditions. Washington attached 4 conditions to that. 1, the sole purpose has to be the practice of law. 2, the people who run the firm or own the firm have to agree to abide by the rules of professional conduct. 3, the lawyers are responsible for those non-lawyer individuals if they don't abide by the rules of professional conduct. And 4, because we're lawyers, if it's not written down, it didn't happen. This all needs to be set forth in writing. So addressing those purposes, the sole purpose requirement, I read that and most would agree that's the sole purpose being the practice of law, keeps the big accounting and big consulting firms out of the game, but still allows lobbyists to participate in law firms, and frankly others, they just can't provide non-legal services. Second requirement attempts to address the concern that business folks or non-lawyers aren't subject to the ethical rules. So here in 5.4D sub 1, they tell the DC bar is telling them that they are subject to those rules. The third requirement, well, you can't disbar anyone who's not a member of the bar to begin with. So we've identified the lawyers who we can disbar and tell them, don't let your non-lawyers violate the rules. And then 4, of course, let's put it all in writing. So shortly after that rule came into effect, I'm sure someone quickly came up with the idea to open a firm in DC with non-lawyer money and expand outward from there. By July of 1991, the ABA had issued formal ethics opinion 91-360, which means it took almost no time for someone to come up with this idea. But so what did 91-360 say? Basically, you can't do that. And the takeaway from 91-360 is that if your practice is limited to the District of Columbia, that's fine. If not, the rules of other states, if you have a multi-jurisdictional practice or your firm does, the rules of those other states are going to govern. So the exception was, or at least was in 1991, effectively limited to DC only firms. Some jurisdictions, like Georgia, have acknowledged the District of Columbia's exception and acknowledged that in their own rules of professional conduct. Georgia Rule 5.4E specified that it's okay for a Georgia lawyer to work with an ABS outside of the state of Georgia and to share fees for that work. The comments to the Georgia rule, to the extent it wasn't clear, make explicitly clear that it's not okay for Georgia lawyers to form alternative business structures, but it is okay for Georgia lawyers or firms to share fees with firms with non-lawyer owners, firms that have non-lawyer owners, if it's permitted in their jurisdiction. So in Georgia, we can't advise our clients on cannabis production and distribution, but we can share fees with an ABS from Washington, D.C. If it comes up. So, got it. It wasn't entirely clear to me whether Georgia's Rule 5.4E was creating a new exception or really just providing some guidance and clarification. But I think if you take away 5.4E in the way that the Ohio rules read, when you include the provisions of 5.4A that prohibit fee sharing except in very limited situations, 5.4E in Georgia probably is a substantive exception. So take a look at some, I've said up until I keep referring to up until very recently. Let's take a look at some more recent developments. In 2020, Utah becomes the first state to allow ABSs or alternative business structures. By a unanimous vote, the Utah Supreme Court adopted Standing Order 15. Standing Order 15 established a 2-year pilot program or a regulatory sandbox that started in August of 2020. That allowed that alternative business structures or non-lawyer ownership of firms. I won't read through the rule, but essentially Utah's version of Rule 5.4D now allows lawyers to practice with non-lawyers, provided that the non-lawyers or organization has been authorized as required by the Utah Supreme Court, Supreme Court's Standing Order number 15. The new sandbox allows entities to use new business structures and service models to provide legal services in Utah after going through a review and approval process. So thank God there's still a bureaucracy to wade through in Utah. And the new revised Utah Rule 5.4 also requires that lawyers disclose in writing that a non-lawyer owns a piece of the firm. Sorry, everybody. In any event, the revised Utah Rule 5.4 also requires that the lawyers disclose in writing that a non-lawyer owns a piece of the firm, or that the non-lawyer exercises managerial authority over the lawyer. That's sub 1. We must also disclose to our clients in writing the financial and managerial structure of the organization. That's sub 2. So how's it going in Utah? Well, recently the Utah Supreme Court voted unanimously to extend the term of the Utah legal regulatory sandbox to 7 years. So their Utah's program now runs through at least August 2027. I'm not sure that's an endorsement of what's happened or more an acknowledgement that you probably need more than 2 years to see if this program is going to work. Recently, the Utah Supreme Court Chief Justice Matthew Durant said, "The court's objectives for regulatory reform are significant and need sufficient time to truly work and create real change in the legal services market in Utah." So I think that's some of the acknowledgement that it needs a little bit more time to see what's going to happen. He went on to say, "We've already seen innovations in legal services in the 2 short years, and we're eager to see more." The Utah's regulatory office has received 47 applications, and the court's authorized 26 entities to offer services so far. The services provided range across legal needs, including family law, end-of-life planning, small business needs. Several entities have been authorized to use non-lawyer human or software providers of legal advice and assistance. All of the entities authorized by the sandbox are required to submit regular reports to the Office of Legal Services Innovation, and the entity's continued authorization is contingent on data showing no evidence of significant consumer harm. And so far, the Utah Commission reports that to date, their office has not observed any evidence of consumer harm in the services being provided in the sandbox. So let's give that some time, and we'll see what happens. Shortly thereafter, in the state category, the first runner-up was the state of Arizona. Arizona abolished Rule 5.4 entirely effective January 1, 2021. Just in time for the insurrection, as it turns out, but as far as I know, there's no evidence relating those two things, so it's probably just a coincidence. But like Utah, there's a licensing program in place. A committee on alternative business structures was established, much like the current Arizona Character and Fitness Committee, to grant or deny applications. And at least one lawyer licensed to practice law in Arizona must be appointed by the ABS to serve as its compliance lawyer. And I think the point to make here, as in Utah, these rules do not permit either non-lawyers or non-state lawyers the ability to practice law. This does not supersede in any way the unauthorized practice of law rules. So you still need to be licensed in Arizona to practice law in Arizona. You still need to be licensed in Utah to practice law in Utah. And you're still subject to all of those unauthorized practice of law rules. This simply allows non-lawyer ownership of those law firms. As of October 2021, Arizona had approved about a dozen entities for licensure, including a LegalZoom subsidiary, and among other things, legal services and immigration, personal injury, mass tort, workers' comp, tax and estate planning. So so far, those are the only two states that have made a move, but discussions are underway, as we'll see. Advantages of allowing non-lawyer ownership of law firms. The reasons that have been cited are the existing rules prevent law firms from expanding, innovating, finding ways to offer more economical services to a larger segment of the market. Is that really the case? Hard to say. Law firms have been pretty innovative in the last decade or two. So I don't know, but that's one of the reasons that's commonly cited. Allowing firms to form multidisciplinary practices that could offer legal services alongside other complementary services, and restrictions on non-lawyer ownership have likely contributed to keeping large law firms smaller than their counterparts in other professional services like accounting and consulting. Again, are those bad? Is that a bad thing? Unclear. So the Utah Supreme Court said in adopting their pilot program, the access to justice crisis across the globe, the United States and Utah has reached a breaking point as to how affordable and accessible civil justice is to people. The 2020 World Justice Project Rules of Law Index ranks the United States 109th of 128 countries. As to that same factor, out of the 37 high-income countries, the United States ranks dead last, and that's from the Utah Supreme Court Standing Order 15 that created the program. Arizona's justifications on their Supreme Court website allows for technological innovation, additional capital to law firms, allows firms to attract the best and brightest non-lawyers out there, and allowing firms to become quote unquote one-stop shops. Arizona's explanation sounds a little corporate to me. Utah's sounds like they'd like to save the world, or at least the United States, both to some degree. Sounds like they're trying to talk themselves into it or sell it. But in any event, they're the only two states so far who have created any exceptions. They're not the only two states that have formed committees or looked into this. Notably, Florida recently had a 10-member committee made up of lawyers from firms like Holland and Knight, Greenberg Traurig, and also from small firms, solo practitioners. So the committee had a wide range of diverse practices. And the committee actually proposed and recommended allowing alternative business structures in Florida. The Florida Bar Board of Governors shot it down 46-0, which probably surprises no one. So it doesn't look like Florida is going to turn the corner anytime soon and allow this. Recently, a California committee was put together to explore this. Their report's not due until late in 2020. So this is probably a topic that is not going away anytime soon. Interestingly enough, well, the advantages to Model Rule 5.4. The only comment to Rule 5.4 that really gets to it at all says the limitations are to protect the lawyer's professional independence of judgment. And in fact, that is the working title of Model Rule 5.4. That seems a little subdued. It's notable that the QTAC Commission in 1983 actually, when proposing the model rules, the initial draft actually provided much more flexibility and allowed non-lawyer ownership of firms. A quote from the QTAC Commission report stated, "To prohibit all intermediary arrangements is to assume that the lawyer's professional judgment is impeded by the fact of being employed by a lay organization. The assumed equivalence between employment and interference with a lawyer's professional judgment is at best tenuous. Applications of unauthorized practice principles only tenuously related to substantial ethical concerns raised by intermediary relationships may be viewed as economic protectionism for the traditional legal service organizations." And they proposed non-lawyer ownership with conditions on interference and adherence to Rule 1.6 on confidentiality and some other rules on advertising and contacting prospective clients. The reaction at the conference, which may shock you, was slightly less than a full-throated endorsement from several of the delegates, and really more than several of the delegates. The one I like, I'll just read one of these here. Mr. Kettlewell, is it cost effective to provide full representation? Is it cost effective to zealously represent your client? Is it cost effective to spend enough time with your client to get the job properly done? I think the answer is no, but clearly as lawyers, as professionals, we must get the job done properly, and we must spend the time, and we must do these things. But what about the business venturer who owns this firm? He who hires and fires the lawyers, they needn't view it that way. So there's strong feeling on both sides of the issue here. It's unclear where this is going, but it's definitely a topic that is going to be with us for a while. It has been with us for a while. It's probably a little bit difficult to predict the impacts just based on a handful of states making the exception. We need to see broad adoption throughout the United States. So stay tuned. Yes, sir.
JA, we have a question for you. Any guesses about why the two states in the Wild West were the first? And do you think it's a clue of things to come?
Well, the short answer to that is no. I don't necessarily I don't have an opinion or even a strong thought on why Arizona or Utah took this on. Frankly, I would have suspected California would have been on the leading edge of this. And my spidey senses tell me the California will turn, but that's not based on anything other than a political hunch. And what was the second part of that question?
Do you think it's a clue of things to come?
Oh, I don't. I think where I was sort of at the wrap up of the presentation, I think having this limited to 2 discrete jurisdictions is not going to provide a lot of data. I think the real impact will come if an overwhelming number of states does this, and then that will trigger some of these big global accounting firms or big global consulting firms to jump into the game in the United States. It's the way we practice law, especially in big law. I think there's too much multi-jurisdictional practice for 2 discrete states to provide much of a data set that we can predict what's going to go on after that.
Thanks, JA. And there's a question for Frank also. I'll let him get up to the podium here. What steps would you recommend lawyers take to make sure that artificial intelligence providers understand the scope and extent of the confidentiality obligations that lawyers must comply with under Rule 1.6?
Okay, I would suggest 3 things. First, tight contracts. And I think the agreement that you have with a provider has to articulate not only the extent of the confidentiality rules that are mandated to us, but those that we would go beyond the scope of just ethics to protect. 2, I would make sure that you're engaging the IT people of your firm, our firm especially, involved in reviewing the contract and understanding. And 3rd, I think meeting person to person with the provider and just doing cross-examinations. And then maybe 4th, soliciting referrals and checking those referrals to see what the experience has been with those providers with respect to confidentiality in the situations that the referrals experienced.
We have a few minutes left, and I thought I'd just throw in a little bit extra commentary. There's a thread that runs through all the presentations this morning, which is that we're seeing a lot of changes in the practice of law. And this isn't isolated just to the United States. The non-lawyer ownership of law firms has been going on in Australia for a couple decades, I think now. And then Great Britain also allowed it, I'm going to say 7 or 8 years ago. And those experiments have taught some lessons. There was, for example, a firm in Australia that went public and then eventually went bankrupt. And so I'm not sure what happened to all those clients, but making the business of law something that is offered by traditional businesses certainly has pitfalls, and that's been the concern of regulators across the country, at least in the US. Canada has also been toying with this. They're interesting because like us, they have provinces that have their own regulation of the profession within that jurisdiction. And so if I'm remembering correctly, I think Ontario began allowing non-lawyer ownership and management of legal services corporations in certain circumstances, primarily in the area of rendering pro bono services. And of course, one of the reasons why that's important or why they thought it was important there is because one of the concerns that has been voiced about non-lawyer ownership is that when you get the supposed influx of assets and ingenuity and development, that is all going to go toward the very profitable parts of the industry. So, injury cases and things like that got a lot of investment in Australia, but the lawyers who are rendering services to indigent people aren't getting a lot of interest from investors, not surprisingly. So there's a lot of tension that is being looked at by regulators around the country here. Why would Arizona and Utah say it was okay? Maybe the West has a more pro-business kind of attitude toward things. But, certainly the fact that there's so much pressure for multi-jurisdictional practice now means that the lawyers in some states are going to be under pressure from states that are liberalizing their rules and allowing more investment and things like that. And that's going to be, I think, safe to say, is going to change the face of how law is provided to people. And I have said for a long time that our practice is going to be unrecognizable in 10 years from what it is now. The way we sit in our offices or whatever our offices are, the way we utilize artificial intelligence, the way we communicate with clients, the way we communicate with courts, all that's going to be different, and in ways that we can't predict as we sit here now. That's the disquieting part of it. For those of us who work hard in the ethics aspect, we are constantly trying to remind everybody else who's in the more profit-based aspect of the practice that there are real reasons in terms of our professionalism and our service to the community at large why we have to remember what our purpose is and not just be focused on profit forever. How that plays out, we're not sure, but hopefully we'll be able to maintain some integrity and still be able to work from our homes in Florida. So unless there's other questions, we're going to take our next break. We will come back for our last segment at 11:30 when we will hear Karen Rubin talk about professionalism, something she's lecturing me about constantly. For those keeping track, the tracking code for the second segment is TH1208P. So we will see you all back at 11:30. Thanks.
Welcome back, everyone, from the break. I'm Karen Rubin, and for our last half hour together, we're going to talk about some professionalism issues, including professionalism as a wellness issue, professionalism in dealing with courts, professionalism in dealing with opposing counsel. And I hope to have some time for questions at the end, either live or in the chat. But first, let's talk for a second about what is professionalism. There's no real consensus on how to define professionalism. Sometimes the word professionalism is used as a synonym for civility, being polite to each other. Sometimes it refers to the law as a higher calling than merely going to work and earning a dollar. Maybe what we can do best is echo the late Justice Potter Stewart, who famously described obscenity as we know it when we see it. And I guess I would say that we certainly know when we don't see professionalism. And we can think about professionalism in contrast to the baseline rules of professional conduct that apply to you whenever you practice. We can say that the rules of professional conduct in whatever jurisdiction applies to you, they're like the floor. If you comply with the rules of professional conduct, you're not going to get disciplined. But at the same time, I think we can say that if you just comply with the rules of professional conduct, you may not be acting in accord with the very highest ideals of our profession. And professionalism is that ideal. It's courtesy and collegiality, it's civility, but it's also coupled with zealous advocacy on behalf of our clients. In other words, the rules of professional conduct are the floor, but the ceiling is to act as a professional. So where are our professionalism principles found? If you're attending here live, we provided as a take-home the Ohio Supreme Court's professional ideals for lawyers and judges. And for those of you attending remotely, you have links in your materials and a resource sheet as a link to the resources that I'll be talking about. For those of you who are licensed outside Ohio, every jurisdiction has something similar to these aspirational ideals. The goal is to help lawyers meet the ideals of our profession. There are things to aspire to in dealing with courts, with opposing counsel, and that Ohio Supreme Court resource and those of other jurisdictions also have some very concrete tips for do's and don'ts in acting as a professional. Another major source for resources and principles regarding professionalism is our Ohio Supreme Court's Commission on Professionalism. I'm honored to be one of the commissioners on that commission. And it really is a one-stop shop for everything professionalism related in Ohio. The commission recently launched a series of short videos. They're aimed at junior lawyers, and they really showcase the diversity and strength of our bar all across the state. It has, the series has lawyers and some judges talking about what professionalism means to them. It's aimed at more junior lawyers, but it really is something that is interesting to look at for everybody. As for Northeast Ohio lawyers, our local bar association, the Cleveland Metro Bar Association, has a professionalism creed of its own. Here in Cleveland, the Cleveland Metropolitan Bar Association also operates a ethics hotline. And that exists to answer questions, field questions from lawyers and practitioners on legal ethics and professionalism topics. And other major metro bars also have similar offerings. And we've provided you some links to these resources in your materials. If you're a pessimist, like I sometimes am, you might think that bad behavior in the profession, well, that's just how things are. If you've been practicing even a short time, and I know we have some junior lawyers in the room, and I'm sure participating virtually also, you've probably been brought up against some very bruising situations where people really do not act as their best selves. Or maybe you think that in order to represent your clients, you really have to be like the meanest dog in the dog pound. But if your days are full of interactions that are very harsh and bruising with clients and with judges and with opposing counsel, it's really inevitable that all that is going to have an impact on your mental and physical well-being. It's not surprising that the American Psychological Association has found statistically, empirically, that over time, continued strain on your body from stress can contribute to serious health problems in every organ system in the entire body. Stress contributes to heart disease, high blood pressure, diabetes, mental disorders such as depression and anxiety, and lots of other illnesses. And so in this sense, professionalism is also a wellness issue. This chart is drawn from this year's ABA study published. They do one every year. It's called the Annual Profile of the Legal Profession, and this is from this year's. And it continues to show that as a profession, we struggle with hazardous drinking and we suffer emotionally. And the pandemic hasn't helped. 40% of lawyers surveyed for this year's report said that their overall work-related stress levels had certainly increased since the pandemic began. People of color were very disproportionately affected by the pandemic's impact. 48% of lawyers of color shared that work-related stressors had increased over the last year. Feelings of burnout. 24% of women said that they'd considered leaving the legal profession due to mental health issues, burnout, stress. 17% of men had the same response. When there is a race to the bottom on our behavior with our fellow lawyers, with judges, and with clients, and the way that others interact with us, it can only result in lessening the quality of our professional lives. It can only result in lessening our mental and physical well-being. On the flip side, when we have collegial relationships that are part of our professional life and our day-to-day work, then we are really practicing as true professionals, and we can feel a part of a profession that is solving problems. And then we've got the flip side. It's inevitable that our physical and emotional well-being is improved. I want to mention a resource that Ohio lawyers and judges and law students have, and that's the Ohio Lawyers Assistance Program, or OLAP. It's got a whole range of diagnostic and treatment resources if a mental health or substance issue is affecting your professional life. No professional problem is made worse by putting in a call to OLAP. It's confidential, and under our rules of professional conduct, no personnel working with OLAP has an obligation or can report a lawyer to disciplinary authorities based on that person's communication with OLAP. And that applies to judges and law students as well. And there's a link to OLAP in your materials. And for out-of-state lawyers, every jurisdiction in the country has something like OLAP, in other words, a lawyer assistance program. In addition, lots of law firms and workplaces may have confidential resources that can help lawyers and others with mental health or substance issues. And just please use them if this affects you. It can really save your license and even your life. So let's turn to talking about professionalism before the court. If you're a litigator, whether you manage litigation from a perch as in-house counsel, or whether you're in the trenches, then you know that litigating before a court and your behavior before that court is really your bread and butter. Your professional reputation and really your very livelihood can depend on having a proper relationship with judges and court personnel. But if you read the things that I do, or even the popular press or the New York Times, there's lots of examples of lawyers who just flame out in court proceedings. A few years ago, there was a lawyer from a very large and well-respected firm who stood up in court and told a federal bankruptcy judge that she was a few French fries short of a Happy Meal. The judge exhibited great restraint and a great judicial temperament because she could have revoked the lawyer's pro hoc vice status. Instead, she said that he had to complete a professionalism course, punished with professionalism. The lawyer recognized what trouble he had potentially gotten himself into, and he hired a lawyer of his own, and he immediately went into damage control. He did a bunch of things. He stepped down as head of his firm's practice group. He completed the professionalism course. He pledged himself to donate money to a law school's professionalism institute. He pledged to do 200 hours of pro bono work. So extreme penance. I guess we could wonder whether that penance fits the crime, but it does illustrate the high stakes involved when you lose your cool in front of a court. This summer, a New Jersey lawyer found himself in the crosshairs of an ethics inquiry after going on a rant in a courtroom after the judge ruled adversely to his client in a foreclosure case. This was all over the press. Law.com and the New Jersey Law Journal reported it. And according to those reports, the lawyer argued with the sheriff's officer. He called his adversaries clowns. He told another lawyer, "I'm coming after you too, counselor." He called the judge's ruling extrajudicial. And he repeatedly interrupted the judge when the judge was rendering the ruling. And when the judge asked the lawyer to control himself, he responded, "I have a hard time controlling myself when I see the law being distorted to benefit parties that did wrong." So the judge's substantive ruling against the lawyer's client was upheld on appeal, and the appeals court judges referred the lawyer to the Office of Attorney Ethics to investigate him. A journalist contacted the lawyer and asked for a quote, and the lawyer's reaction was to double down and said, "Decorum is not what they should be focused on. I believe I acted appropriately under the circumstances." So what rule did the New Jersey lawyer potentially violate? It's kind of in the crease between the ethics rules and professionalism. I guess we could look at Rule 8.2. This is the Ohio version. The New Jersey version is basically the same, as kind of a please act politely to the court kind of rule. And it's that a lawyer shall not make a statement with reckless disregard as to its truth or falsity if that statement is about the qualifications or the integrity of a judicial officer. So calling the judge's ruling extrajudicial was kind of the red flag there. 10 days ago, our Ohio Supreme Court handed down a 1-year suspension with 6 months stayed to a lawyer who violated that Rule 8.2. As a disclaimer, Frank DeSantis and I were counsel to the Cleveland Metropolitan Bar Association in prosecuting this case against the lawyer. And what did he do? Well, without investigating in any way the truth of his statements, the lawyer made several statements in a brief filed with the court. And you can see the statements up on the screen here. Kind of like the New Jersey lawyer, the lawyer in this Ohio case said that the court had decided a case based on politics, not law, and referred to the court's supposed political agenda, which was to maximize the revenue of the court's political cronies. The lawyer also pointed to a supposed delay in issuing its opinion, and again, based on extrajudicial factors. And then just to cap it off, the lawyer accused some Court of Appeals judges of fabricating a case holding. Again, this was all in a filed brief. The Ohio Supreme Court, after hearings and evidentiary hearings in front of a panel of the Board of Professional Conduct, and then before the and then the recommendation went to the full board. The state Supreme Court ruled 5-2 that in line with well-settled Ohio and federal precedent, that the First Amendment doesn't entitle lawyers to make statements concerning the integrity of judicial officers with reckless disregard for the truth or falsity of those statements. Chief Justice Maureen O'Connor took the opportunity to write a special concurrence, and she noted that the ethics rules that bar false statements that impugn the integrity of judges, they're not designed to shield judges from unpleasant or offensive criticism. Rather, they exist to preserve public confidence in the fairness and impartiality of our system of justice. Another example of lawyers behaving badly in front of courts is attacking the opposing party in your filings. Whenever judges sit on CLE panels, they very often mention how annoying it is to them when counsel attack the opposing party in their briefs. Judges say that going after your client's opponent or opposing counsel is just a waste of time, and it distracts them, and it honestly calls your own professional reputation into doubt. I pulled some examples of heated rhetoric from a recent federal court brief. It might be marginally unprofessional, but most of all, it's really needless. It doesn't add to your argument, and judges say that it irritates them. So probably something really to steer clear of. This past spring, a California Court of Appeals affirmed an order that slashed attorney fees that were awarded because the lawyer involved engaged in incivility. The lawyer was representing himself and his wife. They won, and they were entitled to statutory attorney fees, but the Court of Appeals said, we're going to affirm slashing your fees. There was just a lack of civility in the briefing on the fee issue. It was replete with attacks on defense counsel and inflammatory language, wrote the court. In some great language, the court said, excellent lawyers deserve higher fees, and excellent lawyers are civil. The court went on to talk about incivility being like sand in the gears. And when you put that sand in the gears, it really defeats the purpose of the legal profession. And the court said, what's that purpose? The purpose is to help people resolve disputes cheaply, swiftly, fairly, and justly. And when lawyers abandon civility and go to war against each other, the court said, all sides lose, as does the justice system. Why? Because the justice system has to supervise the hostilities. And against this backdrop, the court said it was good for lawyers to know that their low blows may return to hit them in the pocketbook. So here's a lawyer who won the case and yet didn't get a fee recovery as large as it could have been because of incivility. Professionalism issues in dealing with courts can spill over into ethics rule issues and sanction issues, and it's a little bit hard to draw the line. But keeping your composure and maintaining dignity and not taking events in court personally, these are all ways to keep your own stress low and steer clear of potential disciplinary issues. Our Ohio Supreme Court's Commission on Professionalism has a very good 2-page guide. It's got practical tips. It's called Professionalism Do's and Don'ts, Professionalism in the Courtroom. And it's contained in the booklet that we included with our materials. So let's talk a little bit about professionalism and opposing counsel. Maybe the hardest aspect of acting professional is dealing with opposing counsel. In the 80s, the term Rambo lawyering was born, kind of a no holds barred, who can be the meanest, no compromise, junkyard dog lawyer. And the late Chief Justice Warren Burger wrote a law review article decrying Rambo lawyering, saying that, look, we're officers of the court. We should be problem solvers, harmonizers, and peacemakers. We should be the healers, not the promoters of conflict. Rambo lawyers are still with us, despite widespread judicial criticism of them. And just before a lawyer acts like Rambo, think about the potential downsides. They're all very well documented in the literature on professionalism and civility. I've practiced in Cleveland my whole career, 36 years here with Thompson Hine. And what I've learned is that this is a small town, but I don't think that's unique. When it comes to lawyering, I think a lot of towns, a lot of big cities are like small towns in that you are practicing with and against the same people over and over again. Some of them many of them may be people that you have gone to law school with. It's a very small world, essentially, in our profession, and what goes around really comes around. And creating a spiral of distrust, animosity, it brings stress, it brings depression, anxiety, all of that with all of their physical effects on you. It also can't help but create professional dissatisfaction. And that can obviously have negative impacts via court sanctions, bar complaints, and it wastes time. It wastes your time, it wastes your client's time, it wastes the court's time, and it can actually increase costs for you and your client. So tips for dealing with unprofessional opponents. This is my last point, and then we'll get to some questions. What are some tips to avoid getting into the trenches with a lawyer who's not acting professionally? Take the high road. You be the professional in the relationship. Try to deflect rather than directly engaging with Rambo's more extreme tactics. Don't retaliate. Sometimes you can shame the opposing lawyer into acting professional by you being the professional, doing so yourself. Setting deposition dates arbitrarily. How should you respond? Do it in writing. Explain why it doesn't work for you. And if Rambo doesn't respond or still refuses to reschedule an arbitrarily set deposition, file a motion for protective order. You might get fees. In other words, you're the good guy, the other guy's the unreasonable guy. Keeping your cool usually means that you win. Even if you don't have a Rambo lawyer on the other side, your day-to-day dealings with opposing counsel can cause friction. It just never helps you, it never helps your client, and it never helps your blood pressure for you to get angry. So keeping your own cool usually means a much better outcome for everybody involved. So before I take questions, I just want to say thanks so much for attending today, and to send best greetings and wishes for happy holidays and a happy new year when it rolls around from me and from the whole Thompson Hine family, from all of us in Thompson Hine's Office of General Counsel. I also want to point you toward our ethics blog, The Law for Lawyers Today. We try to push out very timely and interesting content on all things involved in the law of lawyering. We've won awards from the ABA Journal a couple different times, and you can subscribe to have it pop into your email inbox. You can also view it on Lexology if you're a Lexology subscriber. So do we have any questions?
There is one question. Are there any practical solutions being discussed by the Commission on Professionalism related to the stress issues that you talked about earlier? It seems like things like caps on hours or mandatory time off aren't workable.
Mandatory time off. I love that concept. Cap on hours. I'm all for it. The Commission on Professionalism has a great resource package for addressed to lawyer well-being, and it's I think it's accessible through the Commission's website. I'm not aware of any rules on the ground solutions like capping hours or mandatory time off or a blackout time for cell phones, you know. But you know, those are all things that we can be agents of change for in advocating for our own well-being and the well-being of other lawyers and our colleagues with you know, with our firms. And innovative solutions are always something that should be promoted. Lawyer well-being and wellness is a huge, huge buzzword now, and it's because it's you know, a pervasive issue in our high-stress profession. So I hope that kind of answers it. Any other questions from anybody in the room? I have a housekeeping correction. Here's the tracking code for this professionalism segment. The tracking code for the last section, the previous section, was initially wrong in the chat, but was corrected. It was always right on the screen. But as we lawyers like to say, for the avoidance of all doubt, the tracking code for segment 1 was TH1208L. The tracking code for segment 2 was TH1208P, like in Paul. And the tracking code for this segment, again, it's up on the screen, TH1208E. So thank you so much for attending. All of us wish you safe travels wherever you may go. And that concludes our seminar.